People v. Williams.
Good afternoon, Anna Jorovleva for appellant. I'd like to reserve 4 minutes for rebuttal.
Yes.
If this court were to hold that the glaring inaccuracy in the People's 5A certification here had no bearing on their ability to validly declare ready, then a very important new prerequisite for trial readiness enacted by the legislature would be nothing more than an empty paperwork requirement. The facially insufficient count here would have been noticed upon a 1-minute reading of both the complaint, the superseding information, which was not the same thing as the complaint with a supporting deposition attached. It was an entirely new document with new factual allegations. And most importantly, by the prosecutor who was getting ready to certify that all counts were facially sufficient under 5A. If that prosecutor had taken a minute to read the complaint, she would have immediately realized that she was not able to make that certification.
Counsel, assuming you're correct that there's some culpable failure to review that particular provision, which I think you called it glaring, and I'll give you that, it's glaring, but it's also part of a much larger document, so there's a proportionality question there that we can explore later. But why is it that the appropriate remedy for that single glaring omission is the dismissal of the entire information?
Because that's what the legislature intended by passing 5A. It's
And
very
where can you point to that in the statute? Where does it say that the information should be dismissed?
5A says that a statement of readiness cannot be valid without the certification. If the statement of readiness is
You
invalid,
do have the certification. What you have, I believe you just argued, is an inaccurate certification. But where does the statute address how to deal with omissions, inaccuracies, intentional falsehoods, whatever, whatever could cause that kind of omission to occur? How does the statute address that? Because I don't see it.
There's 2 places. The first is the plain text of 5A. The ordinary meaning of the word certify necessarily implies that the prosecutor making the certification took some steps to make sure that what they were certifying to is accurate. There was no need to insert the word correct or accurate in front of certify.
What happens if there's, a reasonable good faith belief that the prosecutor has? Maybe that's not this case, but in a different case, and it turns out down the road that a court determines that that was not correct.
Our primary contention is that in a case like that, again, we don't have it here, but if there's a close legal sufficiency question, it should still result in the invalidation of the certification and the statement of readiness. And I think it's really important to keep in mind.
And you would say that requires dismissal in its entirety as here?
Yes, Your Honor.
And why is that, why is that consistent with the purposes of the statute?
Because the people bear a very serious burden.
Well, that's why I asked you if there's a, if there's a good faith effort to make the certification. And let's assume that it's a circumstance where you don't dispute that. There's diligence exercised, et cetera. Why does it further the purposes of the statute to dismiss it in its entirety? That's what I'm trying to understand.
I think the legislature very deliberately used the word all counts in 5A. Their intention was to tie the validity of each count to the threat of the dismissal of the entire instrument. That was the incentive
So you would
structure.
treat this, I take it, as sort of a strict liability requirement as compared with discovery, where you have to exercise some due diligence? So even the most good faith, representation that a court later turns around and says, no, that's not sufficient.
To the extent the court is concerned about those very close legal sufficiency questions, we do propose in the alternative that the court adopt a diligence standard for 5A, similar to what the standard is for discovery in Bay. That would give some wiggle room, but still further the purpose of the
How would
statute.
you articulate that diligence standard? What is it that the submitting party would need to do in order to show diligence?
Actually, a good example is in a trial court decision that was cited by the appellate term in its decision below. That was People v. Carter. So there was a very close legal sufficiency question about whether the forcible element of forcible touching was made out by the conduct alleged in the accusatory instrument. The court decided that the forcible touching count was facially insufficient, but it held that the 5A certification was still valid because the people exercised good faith and due diligence. And what the court said is the people researched and cited numerous cases in support of the sufficiency of the charge and went on to explain that it was a very subtle legal question with which the court disagreed.
It sounds like, just reading that language here from where you're standing, it sounds like it's almost the same as a motion to dismiss a charge for facial insufficiency. So are you insinuating that the people's burden when they file these certifications is to somehow establish that these charges would survive a motion to dismiss before the court, like the one you made in this very case?
Well, again, we don't have the close question here, but if there was a close legal question, they could put in the certification. They don't have to. Instead, if the defendant moved for dismissal of the one insufficient count and for 30-30 dismissal.
No, I just want to know, I want to know if your conception of good faith due diligence goes so far as to say they're certifying that this count or these counts would survive a motion to dismiss before a court. On pain of, I would assume, if they're wrong, if you successfully move to dismiss, they filed an illusory COC, or Statement of Readiness.
So the people in their opposition to a 30-30 motion where there is the close legal question presumably would make diligent legal arguments about why they think the elements of the count in dispute were made out. And based on that response to the 30-30 motion, in that close legal question type of case, then the trial court could take a look at that opposition and make the diligence analysis there.
And they could conceivably say, well, they weren't, it wasn't a charge that could be maintained. It was a charge that needed to be dismissed. However, it was nonetheless good faith diligent. Is that the mechanism you envision?
Right, that just like in this Carter opinion, the people exercised due diligence, they did legal research, they made reasonable, plausible arguments about why the charge was sufficient. So in that case, the 30-30 motion could be denied, but one insufficient count would be dismissed.
Just one more question from me. I want to take you back to your original statement about, this is your alternative argument, but your original argument is that what should happen here is a complete dismissal. And I'm wondering how you can elucidate for us what was the motivation behind creating such a severe outcome for an inaccurate, incorrect state certification?
The legislature's motivation was precisely to create this threat of potential 30-30 dismissal if the prosecutor does not very carefully go through their accusatory instrument.
Wasn't it really about partial conversions? Wasn't that the impetus for this certification? So that the people couldn't come in a case and say, you know what, we're going to make an information on the first two counts, but on the next two counts, we're not ready to do that. So we'd like to proceed on the first two counts. And this idea of half the counts on a complaint being able to move forward and the other ones not, I think the legislature said, look, people, you have to make a decision. Either you're going to make a certification and say that everything's ready and you can proceed and then motions can continue, or you're not going to be able to say that you're ready because you haven't certified all the counts. That was my understanding of what was behind the certification requirement in 5A.
That was one of the purposes, Your Honor, and our rule is completely consistent with ending the practice of partial conversion. If there was no penalty to the people from leaving unconverted counts in the complaint, then partial conversion could continue. Because
So why isn't it a sufficient penalty to require dismissal of the insufficient count only?
because the legislature has decided to tether a certification about the sufficiency of all counts to 30-30 dismissal.
No, they haven't. And there was a bill that was pending where they did do that expressly. There was a bill that was pending that said, upon a local criminal court accusatory instrument, a statement of readiness shall not be valid unless all counts charged meet the requirements of subdivision 1, 2, 3, et cetera. That bill was not enacted. The legislature made a specific call not to enact this bill and then instead enacted this certification.
I think there's two reasons that it was switched to a certification requirement that aren't, we don't care if the counts are sufficient or not. The first reason is that it then mirrors the mechanism for discovery certifications. The people are required to certify sufficiency. And the second reason is, under the first version, the people would not be able to make a separate certification declaration of sufficiency of the entire instrument. So now,
But under discovery, the certification first had to be proper, then they changed it to valid. There's none of that language here. So why isn't the purpose exactly what happened here? That once the people couldn't meet the certification, that count gets dismissed. Because before, and correct me if I'm wrong, that motion couldn't have been made by the defense until the 30-30 time had elapsed on that count, because there was this partial conversion. So there would never be an opportunity for the defense to challenge those counts until 30-30 expired on those counts. And what the legislature said is, look, we need to move these along. When you're making a certification, there's no partial conversion. Once you make that conversion, then all motions practice will continue. The defense can make their motion, which happened here, and the count gets dismissed if it's not certified correctly. Why isn't that exactly what happened here, what was supposed to happen?
what was supposed to happen here was dismissal of the entire instrument under 3030.
Again, what is your authority for saying that?
I think it flows directly from the text of 5A. To certify something has to have some meaning. If there is no inquiry into the accuracy of the certification.
I mean, they could have said an accurate certification. They didn't say that. There's other instances in the CPL I found, 10.40, where the attorney certifies in good faith. That's subsection 1, subsection 2, where the attorney certifies in good faith. There wasn't that requirement here. They just said a certification.
I see my red light is on. I'll just answer Your Honor's question. Again, I think if we were to read into this provision that what the legislature intended is for a certification to be okay with no inquiry into its accuracy, there would have been no purpose to passing this provision, because then the people could simply copy and paste certification language in each case with no penalty.
But the penalty is the dismissal of the count, exactly what happened here. Is that not penalty?
That would be the available penalty before the passage of 5A. I think 5A was specifically designed
That would not
to
have been the
create-
appropriate penalty before 5A under a partial conversion system. Do you disagree with that?
I'm not sure I'm understanding the question.
Before, if you had converted 2 counts
Right.
and had not converted 2 counts, the defense could not have made motions on the 2 unconverted counts until 30-30 time had expired on those counts. But now, they can, which is exactly what happened here. The defense was able to make their motions and say this count is insufficient. Count got dismissed.
I think the purpose of 5A was to end the previous practice of piecemeal dismissal of counts, which if...
And isn't that exactly what happened here? They had to certify that each and every count was ready, and it opened a window for the defendant to start making motions sooner than the 30-30 time. And indeed, with respect to the count that was improperly certified, a dismissal was obtained. I feel like, not to repeat what you've already heard, what they were trying to fix got fixed here because the improperly certified charge was dismissed. And there was no opportunity for the people to engage in partial readiness statements.
Again, I think under a reading where we're not looking into the accuracy of the certification, the people aren't going to be incentivized to make sure they're ready, i.e. that each count is
But
sufficient.
then you can have all the charges dismissed. If they just cut and paste a bunch of affirmative statements with respect to charges that are not compliant, you can have each and every one of those charges dismissed. Couldn't you?
Only if each charge is facially insufficient, then
Yeah.
correct.
Yeah.
Right,
Thank you.
thank you.
May it please the court, Melissa Owen for the respondent. The legislature could have written 5A to say that all counts in the accusatory instrument have to be facially sufficient, be converted, or otherwise dismissed.
So what's your reading of what the certification means or what its requirement is with 5A?
The requirement is that the prosecutor acting in good faith has
They
to.
didn't say good faith, and as Judge Singas pointed out, there are other places in the code where they specifically say good faith.
That's true, they don't write in good
So why do we
faith.
read good faith in?
Because the option is for an officer of the court to act in bad faith, and that would be a nullity. We have to assume that an officer in court acts with a minimum of good faith. And here, they need to say that to the best of their ability, all counts are facially sufficient or converted. What they cannot do is say ready, stop the 30-30 clock, have an unconverted count on the accusatory instrument, and hope that they can get that supporting dep in before the case is sent out to trial. That's how partial conversion is remedied by the enactment of 5A.
Counsel, but assume that's true, and let's assume, just for purposes of this question, that you're right, this is not the remedy. This is not a practice we would want to encourage, right? Sending a count on, not really reading what the sporting deposition says, and then it gets knocked out later, they have to make a motion. So my question is there, outside of this statute, I don't know the answer to this, is there any authority by the judge to take other actions in response to this type of thing outside of using this statute? So could the judge dismiss the rest of the indictment under some, information under some other power?
I don't believe so, but in your scenario, the prosecutor just sending it on willy-nilly would be in bad faith, and that would make the 5A illusory,
So
and that would
just-
invalidate.
So what's bad faith in your view?
We have to look at what happened and what didn't happen. Here, both the trial court and the appellate term found there was no bad faith because there was no possible strategic benefit to having the lowest possible count of violation be added.
So it sounds like then there is a significant distinction between no bad faith and good faith.
Yeah, I was
It
gonna
sounds to me like you're saying that if this was not nefarious, then even if it was, I think we would agree, not acceptable practice, to send it along, then there is no harm that no consequence that flows from that.
No,
Why
and-
shouldn't the standard be good faith, not an absence of bad faith?
Yes, Your Honor, I'm saying a way to determine whether the prosecutor was acting in good faith is to look to see whether or not indicia of bad faith is present. and
Why
whether it was
shouldn't
not.
an examination of good faith also require a consideration of whether some bare bones diligence was exercised, as opposed to doing nothing?
There should be, and I believe the trial court did that here. When we look at the evolution between the complaint and the superseding information, you could see what happened here. The complaining witness was no
And you
longer
see-
available.
Oh, go ahead, because I've still been struggling to understand how such a glaring omission could get through under a good faith or an absence of bad faith standard. So how did this happen?
The witness was no longer available. The prosecutor who was assigned the case, who did not write the complaint, if you look at the narrative section, it's very clear she's trying to excise all the hearsay. She's reworking the complaint into an information that is sustainable. I believe she did not notice that there was a count in there that should not have been. It's the kind of error that is glaring in retrospect, that makes your face turn red in the privacy of your office, but it is not the practice to just copy and paste a certification to copy
But
and paste.
why does it reflect some exercise of diligence? I think you just called it an omission. You might have even said glaring, but I won't hold you to it because I don't recall. But why isn't a glaring omission an absence of some diligence? I'm not suggesting it's bad faith, but why isn't it the absence of some requisite diligence that we would expect?
I think there was sufficient diligence in the recrafting and the narrative to show that the prosecutor was looking at this document and was attempting to make it into an acceptable information, but she failed.
The prosecutor, I think, has to look at each and every count, not just to look at the document generally, correct?
That's correct, but if we look at what would happen if there is a glaring mistake, under my opposing counsel's view of the rules, any possible mistake would result in dismissal of the entire accusatory instrument, and that sort of disproportionate result cannot be what the legislature intended here. We know that there are close questions of law. It is not this case, but there are close cases where it is close, where this court disagrees with the term, which disagreed with the trial court, where panels of judges disagree amongst
But
themselves.
why wouldn't a due diligence or good faith, whatever the articulation is that would make sense, why wouldn't a standard along those lines address that consideration where there are some close questions of legal sufficiency and there is a good faith effort that is made, but a judge down the road decides that in fact you didn't clear the bar?
Well, there should be due diligence and there should be good faith, but there needs to be one rule for all cases. And the result
Why
of that.
couldn't one rule be if there is no diligence exercised, that then the entire, then the consequence that she's suggesting, which is it's set aside in its entirety, that's when that attaches, but not if there's some showing of diligence or good faith? I take that to be the alternative that she is proposing.
Yes, and that could be the case, but this court does not need to reach the alternative because her initial precept is incorrect. When we look at what the draft legislation of this bill was and what the legislature intended 5A to do, they did not say
What's that precept? What's the precept that's incorrect?
that it has to be facially sufficient, converted, or the entire case gets dismissed.
And that's incorrect. Wow, I've lost the ability to speak. That's incorrect because you were going to explain. Go ahead.
Yes, Your Honor. The proposed language of the bill was that the prosecutor had to submit an accusatory instrument that was facially sufficient or converted. They changed that. They took a step back, saying the prosecutor has to certify it.
But then
And not only
what
that,
meaning does that requirement have? I mean, I think there's a point with some force that the word certify means something, and you also say, and I think you're correct, that we would expect that lawyers are acting as officers of the court, being responsible. But if there is no consequence beyond, is your point that dismissal of the count alone is sufficient? What teeth does the requirement have if that's all that is required?
if the prosecutor is acting in bad faith,
No, I'm
Then-
saying if the
oh.
yeah, you're right, pardon me, yes, please go ahead.
if the prosecutor is acting in bad faith, then your 5A is not valid and your statement of readiness is illusory. And depending on when this was brought to the court's attention by defense, inside or outside the 30-30 clock, it may result in dismissal if you can't remedy it. If
So
the
you might have the same
Dismissal of the
result.
count or dismissal of the entire information?
Of the entire information, if defense counsel, as here, waited until the 30-30 clock had run and then brought this to the court's attention, if the prosecutor was found to be acting in bad faith.
Well, I don't understand where you're getting that, and I don't understand practically how that works. Like, let's take this case, which is a pedestrian is hit by an unlicensed driver, and the violation that we're talking about here is a failure to say that the light was red. Explain to me how we would demonstrate that that prosecutor was acting in bad faith by saying that, by not noticing or making the mistake and not converting that the light was red. Like, I don't understand what kind of hearing or what kind of evidence or what kind of arguments would be made in front of a judge to say that that prosecutor was acting in bad faith. How would that go?
Well, we would be arguing that the prosecutor was acting in good faith here. And
How would you even say that, though? What evidence do you have that they were acting in good faith?
Because what benefit was there for the prosecutor to have an errant count on there? It's not a count that makes the
Exactly,
case.
but that's true regardless of good or bad faith.
I think there are errors that could tend to demonstrate bad faith, such as having a count that is not sustainable, that happens to be bail eligible, that it's the only count that is an A when everything else is a violation. Those things were not present here. And if we look at when this case was filed, it was December 21st, or pardon me, when the 5A and the superseding information were filed. It was December 1st, 2021. So this was a relatively junior ADA who was working fully remotely during a COVID surge. Then 7 months later, the defense counsel said, I think there's a facially insufficient count here. And when we're talking about a glaring error, when you wait 7 months, that does suggest that this statute can be weaponized, and it is not going towards the aim of the legislature, which is to have prompt resolution of cases, to have a defendant know earlier on what exactly are the charges that he is facing, what he is going to be going to trial on. It lends a
So the
certainty.
people's position is that 5A is a certification that the prosecutor acted in good faith when she certified counts, and if she did not act in good faith, that the entire information should be dismissed. That's what you're engrafting onto 5A?
It would depend when that happened, if it was inside or outside.
So
the
now there's a
30-30 clock.
temporal element that you're engrafting onto this?
I don't think we need to get there, because when we look at what the draft legislation was and what the draconian result of that would be, it's clear that the legislation did not ask for perfection. We also know that because they didn't modify the word
I
certification.
know, but the problem I'm having now is, at first, it seemed the argument was it was harsh to dismiss all of the counts, even though the others might be perfectly sound. And now you say, if there's bad faith, then it's okay. If there's bad faith, it's okay that everything be dismissed. And the question is, how do you establish the measurement of when it should all be dismissed or when it's not? This good faith or bad faith, how is that to practically work?
Because if the prosecutor was acting in bad faith when they filed the certification, then the certification is invalid.
When you say bad faith, the question is, okay, so give me the tools to consider when it's bad faith.
In this case, when defense counsel filed his 30-30 motion and said this count is wrong, it would have been bad faith of the prosecutor to say, no, it was correct, we're going to keep going forward with this, even if the court said, no, this count is not sustainable, it's not facially sufficient. That would be a showing of bad faith.
No, but that
If
sounds
this-
like bad faith in opposing the argument to dismiss. But I would assume in a situation like this, it would be the defendant's burden to prove the bad faith? Is that your position?
Yes, Your Honor.
Okay, so what is it that a defendant is going to come in and say, just from looking at the certification and seeing what they saw in this case, a count that is unsupported in any way by non-hearsay allegations? What is it that they're supposed to come in and say relative to bad faith?
In this case, it would be difficult because there was no bad faith to show, because there was no possible reason for the prosecutor to have this count on.
The statute imposes the obligation on the people to certify something. Why would it be the defendant's burden to show bad faith? Why would the burden fall on the defense at all? The obligation in the statute is on you.
The people are obligated to certify.
Yeah.
If defendant thinks that the certification is incorrect for any reason, bad faith or not, it's incumbent upon them to bring it to the court's attention so that it
Sure.
could be resolved.
Well, that's a burden of production, sort of, not proof.
Pardon me?
That's a burden to raise the issue, not a burden to prove the issue.
Yes, Your Honor, and that is essentially what happened here. Defendant filed a motion saying this count doesn't exist in the narrative section of the complaint. I don't think the prosecutor read this instrument, and the trial court took into account the situation, read the complaint, read the superseding information, and made a determination that there was no bad faith, and she arrived at the proper remedy, which is to dismiss the count. That was not sustainable.
So let
And
me stop you for a second and ask you about something you said earlier having to do with a temporal difference. So I assume in that, when you were discussing that, that was in the context of defense counsel waiting a long time to raise it, which may be suggested, I think in your word, weaponizing
It could be.
Okay. So what if defense counsel had actually moved and there was still time left on the 30-30 clock? And I'm asking a question I should know the answer to myself but don't. Could you then have filed a new accusatory instrument that corrected the defect?
We could have.
Could you have filed an amended certification?
It's interesting because there's nothing in the 30-30 legislation that discusses a supplemental 5A the way it does, a supplemental certificate of compliance, but I would assume that you should.
Is
at
that
point.
omission of any legal significance to you? Does it say something to you about the statutory framework or the legislative intent that it doesn't make a provision to amend?
I think it suggests that accuracy is not built into the certification and that the act of certifying, once accomplished by the prosecutor, is what is required from 5A. If there are no further questions, I'd rely on my brief.
Thank you.
Thank you.
I'd like to address why it's so important to hold the people to their burden here of filing an accurate certification. In People v. Alejandro, this court addressed the purpose of the facial sufficiency rules. In the felony context, we have cases presented to a grand jury to make sure that there's sufficient evidence to try a defendant. In the misdemeanor context, the corollary for that is holding prosecutors to a very strict set of requirements about putting forth sufficient information in their pleadings, legally sufficient information to try the defendant. I think in light of that, it's very important to implement a standard for 5A certifications that incentivizes prosecutors to make sure that all counts of their instrument are sufficient.
Okay, let me ask you a question. Suppose that there's a case, and it's a domestic violence case. The top count is an assault and Class A misdemeanor, and there's also a criminal possession of a weapon. Let's say he beat her with a bat, okay? The complainant doesn't want to cooperate. The people file an information based on an excited utterance, and they certify that their counts are converted because of the non-hearsay allegation pursuant to the excited utterance. Fast forward 4 months, 5 months as they're getting ready for trial, defense makes motions, a court decides that really wasn't an excited utterance. So, under your theory, that entire information now is dismissed?
Well, under our alternative due diligence standard, in that case, if there was a very close legal question about did the excited utterance fall under the hearsay exception or not, if the people were able to demonstrate the diligence steps they took, put forward some legal research to show why they did think it fell under the excited utterance exception, in that case, the certification and the statement
Let's say a
of
judge
readiness-
decides, you know what, I didn't think it was a close case at all.
Well, if it's not a close case, Your Honor, then in that case, the hearsay defect could implicate the validity of the certification.
Of the possession of the bat? Why isn't it enough that the top count gets dismissed?
I think that 5A is precluding any sort of piecemeal dismissal.
No,
Again, if a 30-30 motion was filed before trial in
right,
this
but that's not
hypothetical.
this situation. Again, I understand where you're coming from. I just don't think the language of this statute gets you there.
I think the language of the statute is pretty unequivocal. If the legislature did not mean to apply to all counts, the word all wouldn't have been used in 5A's language. I'd also like to address something that my adversary stated about, well, the defendant waited a while to bring this 30-30 motion, that the purpose of 30-30 is to promote the prompt resolution of trials. That is not what the purpose of 30-30 is. The purpose of 30-30 is for the people to get the case ready for trial within the allotted amount of speedy trial time.
Counsel, just to go back to something I asked your adversary here, is there any other power of the court to impose sanctions or take other action in response to, let's say, a bad faith filing or a lack of a good faith filing other than found within this statute? I mean, does the court have discretion to dismiss the information under any other inherent power?
If the entire information were,
No, in these circumstances. Let's say not these facts, but more egregious facts where there's obviously bad faith, but the rule says you can't dismiss the whole indictment. Let's say we put, for hypothetical purposes, that's the rule we say. Like the penalty here is an automatic dismissal of the information, but, you know, the 30-30 remedy. But does the court have another authority to sanction the people in that case?
if it's a case where there's proof a prosecutor is knowingly lying to the court, then, to be honest, I'm not really aware of what the
I'm not
remedies
either.
would be.
Curious. Thank you.
Thank you.
Thank you.